Assalamualaikum warahmatullahi taala wabarakatuh, and very good morning to everyone who watches this video. So in this today video, me myself Muhammad Irsyad Ijlal bin Abdul Khalid alongside with my group members Muhammad Raezal Rahim and also Muhammad Amirul Rafeeq. Today we will be presenting about topics, a very interesting topic given to us. Today we will be discussing in depth about subsidiary legislation. So, without further ado, without wasting any more time, let's go. Okay, so, first, before we go deep into our discussion, we must, I think it's proper for us to look what is the content of our presentation today. So, we will start with introduction. It's like a crash course. Subsidiary legislation, simplified. What is subsidiary legislation? And then we will be discussing about the pros and cons of subsidiary legislation. Is it good? Is it bad? How does it affect our life as a citizen of this country? And then we will see the retrospectivity of subsidiary legislation. After that, we will discuss about control mechanisms for this subsidiary legislation. How do we control this subsidiary legislation power? And then we move to how to amend or to revoke this legislation, this subsidiary legislation. And then after that, we will be discussing about a famous maxim that falls under this subsidiary legislation topic, that is delegatus non potest delega. And after that, we will be summarizing the whole of our discussion. In our conclusion, we'll be summarizing what we learned and important points, of course. So firstly, introduction. What is subsidiary legislation? So let's go. So first, let's we look into the definition given in statutes. So I'll just read out several definitions, all definitions that we can get from statutes from in Section 3 Interpretation Acts 1948 and 1967. So subsidiary legislation was defined as any proclamation, rule, regulation, order, notification, bylaw, or other instrument made under any act, enactment, ordinance, or other lawful authority and having legislative effect. Okay, so now that's number one definition that we can get from written statute. And another definition that we can get from statutes is from 11th schedule of Federal Constitution, where it was written, it was defined, this subsidiary legislation, as any order in council, proclamation, rule, regulation, order, notification, bylaw, or other instrument made under any ordinance, enactment, or other lawful authority and having legislative effect. So from this definition, yes, it's quite hard for, if you just say it's plug this word into some random piece into random person, it would be like, what are you talking about? Like of course they would be shocked. What is there any simplified version for layman, like explain to me like I'm five, what is subsidiary legislation? So don't worry, we got this catered. So we got this easy definition for you. So according to Wan Arfa Hamzah in her book, A First Look at Malaysia Legal System, she defined this subsidiary legislation as a law made through powers delegated by the legislature, i.e. here in Malaysia we have the parliament, to a body or person via an enabling or parent statute. Okay, so from this definition, we can see there are several characteristics of subsidiary legislation. The first characteristic of subsidiary legislation that we can derive from the definition given. So first, subsidiary legislation can only be legislated by the relevant person or body appointed by the parliament. So what that means here is that the parliament, when they legislating the parent act when they legislating the act, the law, parliament will insert legal provision to make clear of whom can make subsidiary legislation under the parent act that the parliament legislate. Some example of who parliament may delegate this power, it could be the minister, it could be the director general of a ministry, or even a panel or body appointed under the parent act. Okay, so that's first. Second characteristic is the transfer of power to make law from parliament to any relevant person or body can only be made through the parent act. Okay, so here the power for other person other than the parliament to make law, it doesn't come out of nowhere. It must have its roots, and the root here is the Parent Act, which was legislated by the parliament. The power to make law is still on the parliament. Yes, but when only it is stated in the Parent Act that any person other than the parliament may make law, only then the power to make law and the law they created is legally recognized. Okay, and then the third characteristic of secondary legislation that we can derive from the definitions given are that this subsidiary legislation, although they are not legislated by the parliament, the official legislative body, they have the legislative effect. It's like uh, those laws, the subsidiary legislation, are legislated by the parliament themselves. So how is that? We can see this in Section 24 of Interpretations Act. It was stated, anything done under subsidiary legislation shall be deemed to be done under the Act or other written law under which the subsidiary legislation was made. Simply put, subsidiary legislation have the same legislative effect as the primary legislation, as the law made by the parliament. And then another characteristics, and of course the last, is the names given to those legislations made through subsidiary legislation. So an easy way to know that you are reading, either you are reading a primary legislation or a secondary one, subsidiary one, is to look at the name. So subsidiary legislation will contain words like proclamation, rule, regulation, order, notification, bylaws, and etc. It goes by many names. But a primary legislation, it will goes by the name of like an act or an ordinance or an enactment, something like that. So yeah, you can see the characteristic of subsidiary legislation here. So we move on next to differences between primary and subsidiary legislation. So as we could see, this is just a simplified version. I mean, if there are more differences, but let's discuss some better than 9. Okay. So first aspect, the aim of those legislations. In primary legislations, those words is just to lay down general policies and principles. And in subsidiary legislation, it sets out the details of the implementation. This is to give the primary legislation its practical effects. So like, let's say example, in Road Transport Act, yes, the general policy, the principle is to keep road safe for everyone, but it doesn't really in the act stated what you can do, what you cannot do. So it's in the subsidiary legislation, it explains about the speed limit, about the specifications of your plate number, your helmet, and what the seatbelt, whatsoever. It's all in the subsidiary legislation. You won't find that kind of thing in the primary legislation. So we move on to another power to make law. Primary legislation, it was vested only to legislative body, i.e. the parliament here in Malaysia. And if we compare it to subsidiary legislation, it could be legislated by any executive bodies like ministers, director general of ministry, even a panel of experts appointed by the parliament. And then the name of the legislation that was legislated, as I said earlier, a primary legislation, it goes by the name of Act of Parliament or the Act, and also it could go by enactment if it was enacted by the state legislative assembly, and or even ordinance if it was older law. But for subsidiary legislation, it goes by the name like rules, regulations, orders, notifications, proclamations, bylaws, and etc. So process to legislate is the next aspect that we will discuss the differences. So in primary legislation, especially the Acts of Parliament, it will go through the way of bill. This bill will need to go through both houses for the readings and votings for Royal Assent, YDPA Assent, and gazetted in Federal Gazette. It's a lengthy process. It was there was exchange of idea, and it was even open for a fight from the opposition. But in subsidiary legislation, the men who vested the power to make the subsidiary legislation, they just need to gazette it in the Federal Gazette through PUA or PUB, Pemberitahu Undangan. That's what PU stands for. And then the amendment process, just for the primary legislation, again, like how to legislate it, they need to go through the parliamentary process. It must originated from either houses, House of Senate or House of Representative, and then it will go to the other houses and then voted, and then they royal assent for YDPA and then gazetted. While for amending the subsidiary legislation, it was easy. The person who was vested with the power to make subsidiary legislation, they can just amend it or revoke it at a moment's notice without and going through the parliamentary process. There's no need for that. So yeah, it's quick and easy. And now we go to the example of subsidiary legislation. We will see how subsidiary legislation impacts our life. So first, we have for first example, and also quite near to us, is when we when we have our driving license. So the legislative, the parliament, they legislate Road Transport Act 1987. So okay, this act is an act legislated by the parliament. So in this act, in section 129, it was stated that the relevant minister may make additional law, this to paraphrase, may make additional law to complement the law in this act. So yes, this section 129 can be said as the parent act or the enabling provision that vested this lawmaking power into executive body. So the minister of transportation, he is the one who has been conferred with the power to make law. So what do this minister do with this power? So he created subsidiary legislation like road transport demerit points rules 2017. So if you enroll into driving class, you will learn that there are several things that give you demerit. It will minus your points in your Kejara system, the driving point system. So if you exceed a certain limit, then your driving license will be, at worst case scenario, revoked, or little best case, it will be suspended for like, I don't know, 3 months, 6 months. So yeah, you won't find those words like if you violate the traffic light, you will be subtracted this point in the act, in the parliamentary act. No, you will not find that. You only find this in the rules, in the subsidiary legislation made by the minister. So yeah, the minister creates legislated subsidiary legislation, i.e. this rule, to further explain, to further give this Road Transport Act the practical effect to the person in our normal life. Okay, so another example that's closer to our life here in today, COVID-19 things, Prevention and Control of Infectious Diseases Act 1988. So this is an act legislated by the Parliament, the official legislative body. So it was stated in this act, in section 11 of this act, again, the relevant minister may make such declaration of this area. It was declared as vulnerable to infection, and the minister may create rules that create law that could control the infection in the area. All right. So the minister of health here in Malaysia. So he is the people or the body that the legislative power has been conferred upon from the parliament. The power to make law was given to this minister of health. During the COVID-19 situation, during March, he came out with the Prevention and Control of Infectious Diseases Measures Within Infected Local Area number 2 Regulations 2020. So this is the subsidiary legislation legislated by the minister. So what happens here is so this minister with the power of to create law through subsidiary legislation given by the parliament to him, he make these regulations. He declare which regions are called as infected area, and then he outlined what is the measures to control this disease, or i.e. here the minister, he advised the prime minister to come up with the movement control order, MCO. So it's through subsidiary legislation. So yes, that's how few examples of how subsidiary legislation affects our life. So yeah, hope that you can see it even better. What is subsidiary legislation? How it impact our life, and how it's good, how it's bad to our life. But again, that will be explained by my friend. So I pass my presentation here next to my friend to explain the pros and cons of subsidiary legislation.
Assalamu alaikum warahmatullahi wabarakatuh to Professor Ashkar and to everyone watching this video. My name is Muhammad Amirul Rafeeq, metric number 2016585, and today I'm going to present on the pros and cons of subsidiary legislation. Now that we have been introduced to subsidiary legislation, allow me to elaborate on the pros and cons of subsidiary legislation. The first advantage of subsidiary legislation that provides benefits to the Parliament especially would be in its capabilities to save the valuable time of the Parliament. We are well versed with the fact that the Parliament does not hold parliamentary sessions all the time. In a given day that the Parliament session is to be held, there will usually be two sessions, a morning session from 10 a.m. to 1 p.m. and an afternoon session from 2:30 p.m. to 5:30 p.m. By delegating their legislative powers to relevant authorities, bodies, or individuals, they could discuss more on the principle of a bill and leave the further minute details to these competent institutions in law. The next advantage of delegated legislation could be perceived when we ponder upon the fact that parliamentary members are limited in numbers and also on their knowledge on certain matters and technicalities. As an example, we could set our gaze on the Environmental Quality Act 1974. This act is relating to the prevention, abatement, control of pollution, enhancement of the environment, and for purposes connected therewith. It would be further beneficial for the Parliament and for the betterment of the related policy to leave the technical matters to experts in the field, as they have sufficient knowledge on the subject matter and they could provide useful insights to ensure proper regulations and implementations of this act. Now, in addition, we could also see that subsidiary legislation provides an advantage in the sense that it could be utilized to respond to new, unexpected, and unprecedented situations swiftly. Under normal circumstances, in legislating an act of parliament, thorough discussions are made to ensure that the act would cover all aspects of the subject matter. But in times where the parliament did not anticipate in the occurrence of an emergency and in urgent need of a piece of law, subsidiary legislation would indeed be a savior in the sense that it could be legislated in a short amount of time and does not need to go through the usual process of passing a bill through parliament. Now, sadly, subsidiary legislation is not all rainbows and triggers, and as all things are, and there are a number of disadvantages that subsidiary legislation poses. The first disadvantage of subsidiary legislation would be that it offends the doctrine of separation of powers. The doctrine of separation of powers is of its essence regarding the matter of how the functions between the three main organs of the government, which is the legislature, which is the parliament, the executive, which is the cabinet, and also the judiciary, which is the courts, is separated, and none of them can interfere with another organ's function, as in the legislature cannot surpass the jurisdiction of the executive, etc. With the implementation of subsidiary legislation, it strips away the sole legislative power of the legislature, hence offends the doctrine of separation of powers. Now, to add to that, subsidiary legislation is also legislated at a large volume, and the problem lies in that the large number of secondary legislations could not possibly be supervised by the parliament. Hence, it could lead to some cases in which a certain subsidiary legislation acts beyond its jurisdiction or ultraviolence.
Thank you, Brother Rafiq, on your elaboration on the pros and cons of subsidiary legislation. Now, I, Muhammad Raezal bin Ibrahim, will continue to the next subtopic of retrospectivity of subsidiary legislation. The question would be, can a subsidiary legislation have retrospective effect on past cases? The three statutes related that I would like to highlight on this subtopic would be Article 7 of Federal Constitution, Section 20 and Section 86, Subclause 2 of the Interpretations Act 1948 and 1967. Article 7 of the Federal Constitution states that no person shall be punished for an act or omission which was not punishable by law when it was done or made, and no person shall suffer greater punishment for an offense than was prescribed by law at the time it was committed. It can be stated that criminal law is against the effect of retrospectivity, as highlighted in Article 7. of the Federal Constitution. However, in Section 20 of the Interpretation Acts 1948 and 1967, 2 points can be highlighted, which is the quote of such subsidiary legislation may be made to operate retrospectively to any date which is not earlier than commencement of the Act or other written law under which it is made. And the other point being, provided that no person shall be made or shall become liable to any penalty in respect of any act done before the date on which the subsidiary legislation was published. Hence, it can be concluded that subsidiary legislation can have retrospective effect, as according to this section. According to the case of Kerajaan Malaysia and Wong Pot Heng, the court held that Section 20 merely permitted the making of retrospective subsidiary legislation, but the source of such power must come from a valid competence stated of the legislature being the Parent Act. If no such power was given, the delegated authority is not entitled to legislate retrospectively. In another case of Said Ibrahim, Said Muhammad and others, and ESO Production Malaysia Incorporated, the court held that for a subsidiary legislation to have retrospective effect, the Parent Act must also provide the person making the subsidiary legislation the power to legislate the retrospective effect. This is held from the Section 20 of the Interpretation Act proviso, being provided that no person shall be made or shall become liable to any penalty in respect of any act done before the date on which the subsidiary legislation was published. Hence, no person shall receive any penalty or be held liable for any act that they have committed before the publishing of the said subsidiary legislation.
Thank you, Raezal, on your discussion on the retrospectivity of subsidiary legislation. Now, I would like to continue this presentation on the controls of subsidiary legislation. Now, in ensuring that a piece of delegated legislation does not exceed its jurisdiction, there are two main controls that could be implemented. Firstly, the legislative control, and secondly, the judicial control. Now, on the legislative control, according to Section 87, Clause A of the Interpretations Act 1948 and 1967, it is stated that subsidiary legislation may at any time be varied, rescinded, or revoked by the same authority and in the same manner by and which it was made. In order for the Parliament to control a subsidiary legislation, the Parliament must include a provision in a Parent Act that basically states that the subsidiary legislation must be laid down before the Parliament to be discussed on after its enforcement through the Gazette. During this laying down of the subsidiary legislation before the Parliament, members of the House could discuss, debate, and question the relevant authority that oversaw the delegated legislation and decide whether to allow or reject a piece of subsidiary legislation. An example we could see would be Section 58, Clause 4 of the Trade Unions Act 1959, in which it was stated that all regulations made under this section shall be laid on the table of the Dewan Rakyat at the first meeting of the Dewan Rakyat after the publication of such regulations in the Gazette. Now, moving on, the next control will be judicial control. Now, the judicial control is the most vital and widely used method in controlling subsidiary legislation. Section 23, Clause 1 of the Section 23, Clause 1 of the Interpretations Act 1948 and 1967 state that any subsidiary legislation that is inconsistent with an act shall be void to the extent of the inconsistency, while Section 87, Clause D of the same Act provides that no subsidiary legislation made under an Act of Parliament or Ordinance shall be inconsistent with any Act of Parliament or Ordinance. Judicial review has been described as the power of a court to review or an official act of government employee or agent for constitutionality or for the violation of basic principles of justice. Now, fundamentally, the judiciary organ of Malaysia has a power to control subsidiary legislation by means of a judicial review. But the pertaining question would be, how can courts apply judicial review to subsidiary legislation? The answer would be simple. It would be through an action or challenge usually initiated by an aggrieved person concerning the validity of a subsidiary legislation. Through this, the courts would scrutinize and review the said delegated legislation and declare whether the piece of subsidiary legislation is void through the doctrine of ultra vires, whether on the grounds of substantial or procedural. Now, in substantive ultra vires of a subsidiary legislation, the authority that was delegated the powers to make law has made the piece of subsidiary legislation beyond the limits of the power constituted in the parent act, let it be through subject matter, purposes, or circumstances. We could refer to the case of Arunamari Plantations, Sendirian Berhad and others versus Lembaga Minyak Sawit Malaysia and others. In the said case, it was held by the High Court of Kuala Lumpur that the Malaysian Palm Oil Board Order 2007 was ultra vires of Section 33 of the Malaysian Palm Oil Board Act 1998. The judgment of this case shows how a court could judicially review a subsidiary legislation in determining whether it is legally valid or otherwise. Now, in procedural ultra vires, the recipient of the delegated power has failed to observe the procedures laid down in the parent act. To further its understanding, we could refer to the Supreme Court case of Datin Azizah binti Abdul Ghani versus Dewan Bandaraya Kuala Lumpur and others, in where the court held that based on the facts of the case, the Datuk Bandar had failed to comply with the requirements set in Rule 5 of the Planning Development Rules 1970 when making the development order. The subsidiary legislation that was made in this case was the development order, and it was deemed as procedural ultra vires and was quashed by the courts as it was not legislated through the means stated in Rule 5 of the Planning Development Rules 1970, in which was the enabling statute.
Thank you on the sharing of the methods of controlling of subsidiary legislation. Next, we will continue to observe how subsidiary legislation is amended and revoked. The three statutes related regarding amending and revoking of subsidiary legislation are Section 22, Section 87, and Section 92 of the Interpretations Act 1948 and 1967. Section 82 of the Interpretations Act states that subsidiary legislation may at any time be amended, varied, rescinded, or revoked by the same authority and in the same manner by and in which it was made. So, any authority that has made a subsidiary legislation has the power to either amend, vary, rescind, or revoke the said subsidiary legislation. Continuation of the same act states that A. Provided that where such authority has been replaced wholly or partially by another authority, the power conferred herein upon the original authority may be exercised by the replacing authority concerning all matters or things within its jurisdiction as if it were the original authority. So, it means that any authority that made the subsidiary legislation, if it were to be replaced by another authority, then the replacing authority has the power and jurisdiction to apply Section 87 towards the said subsidiary legislation that the previous authority has made. Another point that we can elaborate regarding the amendment and revoking of subsidiary legislation are the certain subsidiary legislations taking precedence over others. Section 92 of the Interpretations Act states that subsidiary legislation made by the Yandi Pertuan Agong, the YDPA, takes precedence over others. It is also stated in Section 2 of the Emergency Essential Powers Act 1979. As accordance to Article 150 of the Federal Constitution, the Emergency Essential Powers Act 1979 was enacted in accordance to the YDPA to establish any subsidiary legislation in matters of a state of emergency of the country. Next, we will continue on the maxim of delegatus non potest delegar. The question being, can the already delegated lawmaking power be delegated to another person? The maxim of delegatus non potest delegar can be defined as a delegate cannot further delegate the power to someone else. It is the rule that a person whom a power, trust, or authority is given to act on behalf or for the benefit of another cannot delegate this obligation unless expressly authorized to do so. In the context of subsidiary legislation, the relevant authorities or ministers delegated the statutory power cannot further delegate the power to another body or party. This maxim can be seen applied in the case of Ganat Media Sendirian Berhad and Datuk Bandar Kuala Lumpur. The court held, Abdul Malik Ishaq stated, it means a delegate cannot devolve at the duty of or power delegated to him upon another. Put it in another way, an official whom discretionary power has been entrusted must exercise the power himself, which is in line with the authority of the maxim of delegatus non potest delegar. Another case, in another case of Muhammad Bakir Zakaria and public prosecutor, the court held that the court of children could not delegate the requirement of the parents or guardian of the child being tried upon, as according to Section 88, subsection 1 of the Child Act 2001 to the Welfare Department or any other parties as replacements of them. This section of the Child Act 2001 states that a child must be represented by the parents or guardians when the child is being tried upon. Hence, the authority cannot be easily delegated to the Welfare Department or any other related parties. In applying this maxim, the doctrine of ultra vires is applied. A subdelegated legislation is subject to judicial controls by means of the doctrine of ultra vires. As it has been elaborated by my groupmate previously, we will observe a case that applies this doctrine of ultra vires in accordance to the maxim of delegatus non potest delegar. Can be seen in the case of Johnson Tan Han Seng and public prosecutor and other appeals, where the Essential Security Cases Regulation 1975 were ultra vires to the Emergency Essential Powers Ordinance. It was alleged that the YDPA had delegated his subdelegated powers to the Attorney General, which is against the maxim of delegatus non potest delegar. However, this maxim has its exceptions, as the subdelegation has its exception. This being if the subdelegation is expressly authorized by the statute or parent act granting the power. One main example that we can observe is Article 144, Clause 5b, Subclause I of the Federal Constitution. This article states that as according to the article, the Public Service Commission is given the power to make regulations affecting the public service. Additionally, the Commission was also given power to subdelegate the power to the Public Services Disciplinary Board, which the members are appointed by the YDPA. Hence, the maxim of delegatus non potest delegar is not applied, as there has been an exception due to the statute which explicitly stated allowing the subdelegation to occur.
So thank you, Brother Raezal, for such an interesting discussion on the maxim of delegare non potest delegar. So now we are at the end of our presentation. So here's the conclusion. So from all these points, from the topics, subtopics we discussed in this subsidiary legislation matter, we can see that the presence of subsidiary legislation and its effects on our life today is very, very huge, and it almost impossible for us to run from this subsidiary legislation. And in today's context of governance, it is a important mechanism of governing the government. It helps very much for the government to react to situation surrounding us. So we can foresee that this subsidiary legislation will be here together in our governance, way of governance for a very, very long time. So it is admitted that this subsidiary legislation is a little bit it offends this doctrine of the separation of power that was embedded in our constitution. But after all, this subsidiary legislation, it helped our country, it helped us to achieve stability, to achieve peace, to react to our surrounding swiftly and fast without too much of bureaucracy. And of course, again, as like I said earlier, that this subsidiary legislation will be here with us for a very, very long time, because we see that its pros outweigh the cons, and there is no good reason why we should just abandon this subsidiary legislation all along. And with that, I rest my case here for we rest our case here for this presentation of subsidiary legislation. So thank you again from me, Muhammad Irsyad Ijlal, and my teammates, Raezal and also Amirul Rafeeq, for giving us this opportunity to explain to you guys what is subsidiary legislation. So yes, thank you and see you again in the next presentation.